All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good afternoon, everybody. The afternoon session will give the defense further opportunity to present, in fact, the second part of its closing statement. So now, Mr. Wugon, you have the floor.
Thank you, Mr. President. Mr. President, when we left before the lunch break, I was suggesting to the chamber the evidence which should be looked at in order to determine that there was an absence of policy to commit attacks directed against any civilian population. What I propose to do over the next few minutes is to go over the evidence related to UPC, UPC RP, and FPLC. Mr. President, it is necessary to examine the context in which the UPC political movement was created. It was created in September 2000 while RCD KML was in power. An ethnic conflict had been ongoing since 1999. The basis of the conflict, we can say, opposed members of the Lendu community to members of the Hema community for reasons that are akin to what happened in Rwanda. But the situation there was much more complex with many additional ethnic groups included. Within the population, there were a lot of violence between villages from various communities. The APC, the military arm of the RCD KML, did try to put an end to that conflict from the moment they arrived in Bunia. At the beginning, they were impartial, and they did have good intentions. The evidence reveals, however, that as of 2000, at best, the RCD KML was unable to stop violence of civilians against civilians. At worst, the RCD KML was in fact taking sides with one part of the community, namely the Lendu community. In this context, in September 2000, the UPC was created. We have a founding document which establishes, of course, that the absence of any policy within the FPLC to commit crimes or attacks directed at the civilian population. This document establishes, for example, at Article 5, that the aim of the UPC as a political movement was to put an end to exclusion and intolerance. It was to rehabilitate the people in all of its rights. Looking at Article 6, it is made clear that Article 6 says that every member of the Congolese population, all Congolese, can be members of the UPC. And that is important consideration. Moving on to 2002, on the 17th of April. There was another document important, and it is referred to in English as a managerial staff declaration. Managerial staff means notable. I disagree, or I don't like managerial staff as a translation. Notable means those who were notable and who were not in the RCD KML. The notable included not only Emma, but also members from other ethnic groups. Now, this is not a UPC document per se, but many signatories to this document also signed UPC founding documents. So what happened between September of 2000 and April of 2002? Well, there were many developments. What is known, however, is that the situation deteriorated significantly. The importance of this document is huge because it addresses the concept of Kivu holding. What is Kivu holding concept? Ituri notable complained that all important positions in the administration were given to people coming from the Kivus, as opposed to Iturians. That was the problem, and that was the complaint of the notable in this document. This document has nothing to do with chasing non-originaire. The concept advanced by the prosecution as part of its common plan against non-originaire does not deal with the civilian population. It is a political concept, whereas people were holding power and Iturians, not only Hema, but Iturians in general, wanted to rule and say l'Ituri aux Ituriens. That was the concept, not to do with the civilians or targeted at civilians. Looking at this document, we see at paragraph 5 that the notables are asking soldiers to keep calm. When they are referring to soldiers, they are referring not to soldiers of Thomas Lubanga or not to soldiers that are Hema. They are talking about our glorious soldiers, FAZ, FAC, and APC, who are left to their sad fate by the discriminatory politics of RCD-KML. That's what the soldiers that are referred to in this document. Now, although notables want to ensure that Iturians would get those positions in the administration, they are open and they welcome everyone in Ituri. This is what you see in Article 6, where it is said, and I quote, "Let us reassure our Congolese brothers and expatriates living in Ituri of our legendary hospitality and assuring them peace and security." The Kivu holding concept has nothing to do with violence against civilians. Moving on to a document of 16 May 2002. Following this political declaration, a movement called FRP, Front pour la Réconciliation et la Paix, was created by these same notables of Ituri. This memorandum also reveals the absence of a policy to commit crimes against any civilian population. Thomas Lubanga is not the leader of this FRP movement at that time. And this significantly happens very shortly after the death of Claude, after the separation of Bunia in two parts, and after the meeting sponsored by Uganda and UPDF in Kasese, all of which are referred to in the evidence. Now, the conclusion of this document by FRP announces the following aim: to achieve reconciliation between Iturians, to establish a dialogue with Kinshasa aiming at national reconciliation. This document demonstrates the opposite. And it focuses on the problems which had been created by Mbusa and the need for a reconciliation. As we know, Mr. President, following this document, in August of 2002, the Lompondo political movement, who was the governor and the military sector commander, were chased from Bunia by UPDF. And the context of this chasing is known. Members of the FRP present in Bunia at the time, I'm talking about following Lompondo's departure, began to fill the political vacuum. Because when Lompondo departed, of course, there were no more people in power. We do have a reference to the vice governor who actually was working with the people who remained behind. As the evidence reveals, Thomas Lubanga is not in Bunia at the time, he's in Kinshasa. Why? Because he has been detained there or placed on house arrest with other members of FRP by the central government. With whom? With the collaboration of the Ugandan government. This document on 11 August 2002 is important because it establishes also the absence of a policy to commit any attacks directed at the civilian population. If we look at the conclusion of this document, dated 11 August, it talks about the implementation of a structure. For what purpose? For the purpose of ensuring pacification and reconstruction of Ituri, and for the purpose of working with Kinshasa. This declaration establishes reconstruction and pacification and does not establish any kind of policy to direct attacks against any civilian population. In less than a month later, Thomas Lubanga did return to Bunia, along with the DRC Minister of Human Rights, I believe, Tumba Luaba. On the day of their arrival in Bunia, both of them addressed the population. Let's look together at an extract of Thomas Lubanga's speech on that occasion. The slide before you has the text in English, which is a translation done by the defense. But let's look together at the video.
Nawaza ni ile juhudi ya kuungana katikati yetu ndio yenye tunapasha kufanya, lakini hatutakubali ya kwamba batu baendelee kuua watu katika ile teritwari yetu ya Ituri. Kila mtu iko na droit kwa maisha sawa mwenzake. Hivi wale wenye walikuwa saa zingine na ile mawazo ya kuua wajue sio wakati ya kuifanya, ni haya hatapata faida hata kidogo ndani.
Thomas Lubanga, who went on to become the president of UPC-RP, his speech establishes the absence of a policy to commit crimes against any civilian population. Quite to the contrary, his statement aims at putting an end to the cycle of violence and at protecting the civilian population. Moving on to UPC-RP itself. All of the preceding information was related to UPC. Now, we look at the de facto political body created. It was the ruling political movement in Bunia. The document reflecting the composition of UPC-RP executive is highly relevant. It demonstrates the multi-ethnic composition of the executive, putting in place an effective administrative structure. The evidence reveals, Mr. President, that non-EMA secrétaires nationaux were truly empowered by UPC-RP and Thomas Lubanga to accomplish and to rule and to run this effective administration. In light of these documents, and in light of other documents, moving on to the strategic objective of the UPCRP. Well, we say that the UPC Réconciliation et Paix had the following objectives, which stems from the evidence. 1, peace and reconciliation. 2, putting an end to the cycle of violence in Ituri. 3, ensuring a true and effective dialogue with Kinshasa. Fighting intolerance and exclusion, thereby ensuring rehabilitation of all Congolese people in their rights. Creating an effective governmental administration, and creating a national army capable of protecting the people and defending the territorial integrity of Ituri. The prosecution attaches great importance to the word national. We urge the chamber to take the opposite view. Why do they use the word national? It is the same reasons for which they refer to secrétaires nationaux rather than ministers. Ministers were for the national government, secrétaires nationaux were for Ituri, and yes, they wanted to create a military arm. And it is significant that why they did so, Chef Kawa clearly explained why they felt the need to do so in the speech he delivered later in Mandro. Moving on to the absence of a policy in respect of the first attack as charged. In early November, UPC-RP called upon the FPLC, its military arm, to conduct an operation in Mongwalu. From the orders given to Mr. Ntaganda, the following political objectives of this operation can be summarized as follows. 1, to liberate the people of Mongwalu. There is plenty of evidence on the record which highlights the mistreatment of the population in Mongwalu, the majority of which was, according to the prosecution, Lendu. That was in line with UPC-RP objectives. And that was one of the aims of the operation. And 2, of course, to try and move away the APC and because they did not want the APC to be able to come back to Bunia and to hurt the civilian population. Significantly, Mr. President, following the liberation of Mongwalu, civilians returned living in Mongwalu. And amongst the civilians who returned, there were Lendus. I move on, Mr. President, to December, which is the meeting in Arua. Now, the objective of that meeting was to negotiate with Lendu chiefs. And as mentioned before, the UPC-RP delegation was headed by a non-EMA, Secrétaire National, Jalum Jakumbi. It displays the willingness to meet with the Lendus, the willingness to negotiate with Lendus, and the measures taken to ensure that the Lendu chiefs could attend this meeting. The orders issued to Bosco Ntaganda and then from Bosco Ntaganda to the FPLC to ensure that this could take place are significant. Moving on to 1 January, Mr. President, UPC-RP held a large event in Bunia, inviting all representatives from all communities, including MONUC and UPDF, to attend a swearing-in ceremony of new Secrétaires Nationaux, and of course, holding festivities for the new year. On that occasion, Thomas Lubanga delivered a speech which demonstrates the absence of a policy to commit any attacks against any civilian population. Quite to the contrary, Mr. President, this speech delivered by Thomas Lubanga focuses on one thing. It focuses on bringing all communities to one table. And it is not speech without action. Les babines ont suivi les bottines, ou les bottines ont suivi les babines. There were actions taken which led to the signing of a peace agreement. Moving on to 13 January, UPCRP organized the official launch of the Commission Vérité, Paix et Réconciliation. I've addressed this event already. What is significant is that the members of the CVPR were not selected by UPCRP, but within their own local communities. We have documents and evidence that show the members not being selected by UPCRP. This event defeats any suggestion of a policy to commit crimes against any civilian population. I move to a very important event, mentioned this morning also, but it is necessary to look at a video. The Congo pacification meeting or negotiations. On 14 January, a delegation headed by 3 non-EMA secrétaires nationaux took part in negotiations with Lendu FNE leaders in Congo. Let's take a look, Mr. President, at a video recorded on that day involving Ntaganda, secrétaire national à la pacification et réconciliation, who is also, as the Chamber is well aware, non-EMA.
Ile njoko chama yetu. Adui yetu sio mulendu. Tusikilizane mzuri. Adui ya IPC haiko mulendu. Adui ya IPC haiko muhema. Adui ya IPC haiko kabila fulani. IPC haikujijenga kwa kupigania au kwa kupiganisha kabila fulani. Inafaa tusikilizane mzuri. Wale watu wako wanafanya confusion kuanza kusema ke IPC ilijijenga kwa kupiganisha waleni kwa mfano.
As mentioned, Mr. President, a result of these negotiations, a secondary route was opened from Lipri to Bunia, allowing civilians to circulate freely between the town and these villages. This video further defeats any suggestion that UPCRP had a policy to commit crimes against any civilian population. The opposite is a reality. On 23 January, a meeting with Ugandan delegation took place in Bunia. The aim was to take Thomas Lubanga to Uganda because Uganda was worried that the UPCRP was making too much progress. It's a two-part event. Thomas Lubanga wanted Ugandan representatives, an official delegation, including the son of Museveni, to get a feel for what the population's opinion was regarding the presence of UPDF in Bunia. The notable voted departure of UPDF. That's in evidence. The notable included notable not only from EMA, but from all communities. The population in the second part of the meeting clearly expressed the view that UPDF should go. There's a link between this event, Mr. President, and Thomas Lubanga's plan to provide weapons to Lendu combatants. Thomas Lubanga wanted the UPDF to leave through political action. But of course, he was also willing to negotiate and collaborate with Lendu combatants to ensure that they would go. UPDF was a source of discontent paving the way for violence against the population. I said the son, I made a mistake, Mr. President. It's more the younger brother of Museveni, Salim Saleh, who was a general in the Ugandan army, who was part of that delegation. I move, Mr. President, to RCD Goma's visit to Bunia. Now, this is the most significant accomplishment of the UPC-RP. On 6 to 8 February, following the signing of a political alliance signed in Goma, a visit had 4 different aspects to it. The arrival of the delegation, public speeches by Lubanga and Onusumba, who was the leader of RCD Goma, the signing of a peace agreement during a visit in Yaoundé, and the press conference. I invite you, Mr. President, to take a look at an extract of the press conference, and this is Thomas Lubanga addressing the media.
Ce qui est important sur la cérémonie qui a été faite hier, elle est très importante parce qu'elle a engagé toutes les communautés. Toutes les communautés. Si 2 personnes sur 5 d'une communauté n'ont pas signé, ça signifie que même ces 2-là n'engagent même pas cette communauté. Parce que déjà la majorité de cette communauté a signé avec nous. Donc c'est dire que nous n'avons pas de crainte, mais nous...
As you can see from this video, Mr. President, Mr. Ntaganda was present during that press conference. Mr. Ntaganda was involved in all of these peace initiatives along with Thomas Lubanga. This agreement was a success and a concrete achievement. Nothing in this video or these events highlights a policy to commit crimes against any civilian population. To the contrary, it highlights UPC-RP strategic objectives to sign and success to sign an agreement with all communities. Mr. President, as we know, on 6 March, little soon thereafter, UPC-RP was ousted from Bunia. Thomas Lubanga fled to Goma, leaving behind only a few members of the UPC-RP executive. People left behind, nonetheless, during that time frame, many things happened. First, as we know, many people left. There was a massive exodus of people because they knew that UPDF could not protect them, could not ensure their security. The second, the Commission de Pacification de l'Ituri held its works during that time. Well, despite the fact that UPC-RP had been ousted, they nonetheless participated in the CPI work, and they signed the final document of the Commission de Pacification de l'Ituri. What is significant is that during that time period, Bunia and the surrounding areas became free territory for FNI attacks of all sorts. I recall just one attack that is referred to in the evidence in Drodro, a major massacre. Nothing compared to other events involving, the alleged events involving Emma. A major massacre, one of the major, with many, many people killed. It is amazing to me to see the prosecution and the legal representative blaming UPC-RP for everything that went on, when really the situation, one, was much more complex, and crimes were not committed by UPC-RP, but by others. It's not a two-quoque argument at all. It's simply looking at the complexity of the situation at the time. In early June, Thomas Lubanga returned to Bunia In a speech to the population, he addressed the security problem. Nothing in this speech comes even close to demonstrating a policy to direct attacks against any civilian population. Quite to the contrary, it demonstrates UPCRP intent to restore stability and security in Bunia. Lastly, with respect to UPCRP, we can look at the June to December 2003 period. Arrival of Artemis, departure of FPLC from Bunia at the request of Artemis, numerous attacks launched by FNE during that time frame, and what does Lubanga do? He imposes restraint on FPLC troops. Again, absence of policy to attack any civilian population, and this even though villages with Ima majority are the victims of large massacres and attack. To name but one, the situation which happened in Nizi. Mr. President, I move to FPLC. FPLC, looking at these issues, will allow or should allow the trial chamber to determine the absence of a policy to commit any attacks against any civilian population. I will look at each of those very quickly. The first one, the training of future FPLC members in Mandro. Training in Mandro was conducted for self-defense purposes. The training in Mandro did lead to the creation of the FPLC. The training was based on what? On the raison d'être of the military to protect all civilians. This stems from the evidence and from Mr. Ntaganda's testimony, but not only from Mr. Ntaganda's testimony. The training was conducted pursuant to military organization. Is that wrong? No, that's not wrong. This is what Mr. Ntaganda was good at. Mr. Kisembo would tell him what to do, and he would do it. And we have the organizational chart of the Mandro training in evidence. The evidence establishes that the training in Mandro, or nothing in the training in Mandro, demonstrates a policy to attack any civilian population. Ideology training. Well, we know that there was ideology in Mandro, and Bosco Ntaganda explained what this ideology was. But when Lampondo was ousted in August of 2002, many former APC members joined UPC. And Bosco Ntaganda and Kisembo and others wanted to ensure if we are going to get APC members on board, those APC members who have lost their bearings and who are committing attacks against the civilian population, they will at first go through ideology training in Mandro. This is what happened. The official creation of the FPLC is significant. It was the official military arm or armed branch of the UPCRP. There was an official appointment by a civilian governmental body, de facto. Appointment of one chef d'état-major général and two chefs d'état-major général adjoints. The organization followed a genuine military structure, including a chain of command. Now, even though the structure was like a normal army, this was still a rebel group. This was still a group without resources. But the intent was there to create a good army with a chain of command. And numerous measures were taken by FPLC and UPCRP together. What are those measures? FPLC ideology, heavy weapons training. If you give a heavy weapons, if you give a B-10 to someone who doesn't know how to operate a B-10, it will be a carnage, either for his own troop, but more likely for the target. They insisted on training people on those heavy weapons so that they could be used properly. They obtained uniforms. That's the basis, basic international humanitarian law, to be able to distinguish yourself from a civilian population. If you have a uniform, then you can distinguish yourself. That means that you can trust that your soldiers will be known and will operate pursuant to the chain of command and orders. Implementation of communication. They had no resources. They had to go to P243 to get a VHF base, la base. They had to go through a civilian to ensure that they could speak on the radio over longer distances. But why? Because they want to try and ensure the best possible chain of command in the circumstances. Then we have the exchange of troops. It was important to get the troops from Jérôme. This expanded the territory that would be covered by the military arm of UPCRP. It was important to expand, to ensure that they could protect the population, not only in Bunia, but in other areas. But to ensure that it is well done. Say, Jérôme, you're going to send me 300 of your troops of a different ethnic origin. I'm going to send you 300 of mine. You don't have weapons? I'll send my troops with weapons. You send your troops without weapons. And then Bosco Ntaganda will travel there to ensure that everything is, the glue to everything is put together to ensure proper conduct of operation. And lastly, of course, the directives issued by UPCRP executive directly to the soldiers. The only negative side to this, Thomas Lubanga should have addressed the soldiers himself. But he did in Wampara. On that day, where was he? I don't know, but he entrusted Chef Kawa to do so. FPLC ideology we've covered before, but that is in evidence. I will move on. The Chef Kawa's speech in Mandro, we talked many times. I invite you, Mr. President, to take a look at his speech in Mandro. We have an English translation on the screen, and we will see the original in the video.
Waondoa, kwani tumeona kama wananchi wameteseka. Kwa kitu yote tutafanya, kwanza tunaangalia endelea ya mwananchi, security ya mwananchi na mali za kwake. Na hii jeshi hatupendi kuwa jeshi ya ukabila. Sisi hatuna lazima jeshi ya ukabila, kwani hii ukabila ndio iliharibu hata ilitia mauaji. Tunapenda mkuwe jeshi ya kuchunga kabila yote, ikuwe jeshi ya kuchunga wananchi na mali za kwao. Tunajua kama hali ni nguvu, lakini tunajaribu kuwasaidia na tutakuja pamoja na nyinyi. Na mimi nawaza hata president kwetu Thomas Lubanga kila mara iko pamoja na ninyi, ndio maana hata mnapata uniform, mnapata vifaa zote, na msiwazi kama tunaweza.
Not necessary, Mr. President, to repeat that the troops addressed by Chef Kawa on this occasion are the troops that went on to participate in the FPLC operations with a nest. There were two of those, two attempts in Mongwalu, as revealed by the evidence. It is significant that in its brief, the prosecution alleges that these two attempts were separated by a long period, which is absolutely not the case, pursuant to the evidence. And I move on to the contextual attacks as alleged by the prosecution. We have to look at those two. There are 6 of them. 4 before the first attack as charged, and 2 after the second attack as charged. First of all, the prosecution's submissions are wholly incomplete. Can we use those 2 words together? I'm not sure, but they're incomplete. Contextual attacks by the prosecution represent an incomplete overview of all operations. The prosecution does not address in its submissions what happened in Luga, pursuant to the testimony of D17, what happened to Comanda, testimony of Mr. Ntaganda and D17, Lendu combatants' attack on Nyakunde against FPLC, that was also involving. That's when Kisembo was injured. Kandoyi and other FPLC operations in the Northeast operational sector, not a word about that. FPLC operations conducted after the first attack and before the second attack. UPDF attack against the FPLC following the 6 March fighting in 2003. FPLC third operation in Mongwalu in June, during which no crimes were committed by FPLC, and little, if any, evidence has been adduced by the prosecution. Restraint manifested by FPLC following the arrival of Artemis, despite multiple attacks launched by FNE. When you look at all these operations, you cannot look at the 6 contextual attacks and draw any conclusions without looking at also those attacks. Now, it is significant that the logbook, as mentioned this morning, gives you the complete picture, the true picture of the conduct of operations between 19 November and 22 February. The logbooks clearly establish the absence of a policy to commit attacks. Regarding the 4 attacks prior to the first contextual attack, before the first attack as charged, there's very little incriminating evidence adduced by the prosecution. And prosecution evidence is directly contradicted by defense reliable evidence. We have to look at, for these attacks, at P31, P14, but they were not involved. At P898 and P888, we say their evidence is wholly unreliable, as is that of P907. It's simply not possible to derive the existence of an FPLC policy to attack any civilian population from the evidence available in relation to these attacks. Prosecution also ignores the testimony of Mr. Ntaganda, who explained what he did immediately after Lopondo left, all the forces that were deployed on the orders of Kisembo, and why, to prevent the APC or others to attack Bunia. Regarding the 2 alleged contextual attacks after the second attack as charged, again, very little direct incriminating evidence. And again, the prosecution evidence is directly contradicted by defense reliable evidence. Now, on 6 March, the FPLC attacked UPDF. I remember the trial chamber asking, well, who attacked? Well, Mr. Ntaganda explained, we did. He did not walk back. He did not try to say that UPDF had attacked. He said we did. Why? Because they were not up to par. They could not face UPDF other than in a surprise operation. And they did attack, but no crimes were committed. If crimes were committed on that day, the crimes were committed by FNE, as the evidence reveals. From the departure of UPDF on 6 May until on 6 May 2003, this is the second one, it's FNE who committed all kinds of crimes and all kinds of attacks directed at any civilian population. The involvement of FPLC was limited to liberating Bunia on 12 and 13 May. It cannot be derived that there was an FPLC policy to attack any civilian population, even from these 2 attacks, either considered individually or collectively. Conclusion, Mr. President, when we look at what the training in Mando, we look at the ideology of former APC members, We look at, for ideology training, we look at the measures to ensure that FPLC will be a law-abiding and disciplined military force, including all the numerous measures to prevent taken by Mr. Ntaganda as recognized by the prosecution. We look at the conduct of FPLC operations as revealed by the Ntaganda logbook. We look at the June 2003 FPLC operation in Mongwalu, where no crimes were committed. We look at the restraint demonstrated by FPLC after the arrival of Artemis. When we look at all of that, it is evident, Mr. President, that neither the UPC-RP nor the FPLC had or acted pursuant to or in furtherance of a policy to commit attacks against any civilian population. Consequently, it is not necessary to look at the other essential elements related to crimes against humanity, and Bosco Ntaganda must be acquitted of counts 1, 3, 4, 5, 10, and 12. Now, the relationship, as introduced earlier, with respect to the absence of a policy to direct attacks against any civilian population and the alleged common plan. As was done in the Mbarushimana, we say that the absence of a UPC-RP or FPLC policy to commit attacks directed against any civilian population also defeats the prosecution allegation that a common plan to drive out members of the non-Ima population, Lendu and non-originaire, according to the prosecution, from the areas they took over. In Mbarushimana, this is what the chamber, the pretrial chamber, said. The chamber recalls the finding made in the context of the analysis of the contextual elements of crimes against humanity, namely, that in light of the analysis of the evidence as a whole, the majority is unable to be satisfied to the threshold of substantial grounds to believe that the FDLR pursued the policy of attacking the civilian population. This finding leads the majority to take the view that based on the analysis of the evidence as a whole, there are likewise not substantial grounds to believe that the FDLR leadership constituted a group of persons acting with a common purpose within the meaning of Article 25(3)(d) of the statute. In particular, in light of the requirement that the common purpose pursued by the group must have at least an element of criminality. Now, for the record and in ending, Mr. President, I will say, when we look at the FDLR, Mr. Ntaganda, on the internet, despite his reputation, is a child compared to what the internet says the FDLR would have done in the area. And yet, this was the result of the evidence. And we say the same result should be adopted or should be found by the chamber. We move to the legal consequences of the absence of a common plan to drive out members of the non-Ima population from the areas, which will now be addressed by my colleague, Christopher Gosnell. Thank you, Mr. President, unless you have questions for my presentation.
I don't have any question at the moment. I thank you very much, Mr. Bouton.
Thank you, Mr. President. I need to ask for the floor to be given to the external computer on the other side so that they can operate the PowerPoint.
Court officer, please assist.
You do have the floor.
Mr. Gosnell, please.
Thank you, Mr. President. Good afternoon, Your Honors. Before eventually coming on to the issue of the prosecution's evidence in respect of child soldiers, it falls to me as foreshadowed by my colleague, Maître Bourgon, to address you on some legal issues, and three legal issues, in fact, that we consider to be particularly important in guiding and governing your analysis of the very extensive and complex evidence in this case. And those three issues are, first, the standard and burden of proof, the findings necessary to enter a conviction for the extended forms of commission under Article 25(3)(a), and the scope of the charges on which you can properly enter a conviction under Article 74(2). Now, Your Honors, we all know, and it scarcely bears repeating, that the burden in a criminal case rests on the prosecution to prove beyond a reasonable doubt. And that burden and that standard applies to each and every element of the crime and mode of liability with which the accused is charged in the UDCC. When inferences are based on circumstantial evidence, that is, a body of disparate pieces of evidence that purportedly should lead you to a particular conclusion, that inference must be the only reasonable inference available, not just one of several, and not even just the most or likely or most reasonable. It must be the only reasonable inference available. And this standard means that an individual who is likely guilty or even probably guilty must be found not guilty in the eyes of the law. That's the nature of the value that this justice system places on individual liberty and on ensuring that no one is wrongly convicted. On the screen in front of you, you see the statement from the Bemba appeals judgment that the standard, if we can go back one screen, please, that the standard applies to those facts that correspond to the elements of the crime and mode of liability. And in this case, that includes the age of any alleged child soldier. That includes whether or not the alleged child soldier was actually enlisted. That includes whether or not an alleged child soldier was used. That includes whether or not there is a widespread or systematic attack against a civilian population. And it applies to each and every one of the intent and knowledge elements for each and every crime and mode of liability charged against Mr. Ntaganda. We say that's important to bear in mind and easy to forget, especially when confronted with submissions concerning the continuous nature of crimes, the collective nature of crimes, the fact that they were repeated, pleadings that are very general in terms of geographic scope and temporal scope. But at the end of the day, what must be remembered is that indeed this standard applies to each and every element of the crimes charged. What is reasonable doubt? Answering that question is a little bit like trying to describe the color blue. You know it when you see it, but it's not very easy to put into words. Your Honors, but it is nevertheless useful to pause for a moment and consider the extraordinary context in which you are called upon to make this assessment. Almost none of us in this room have any intimate knowledge of Congolese society. Almost none of us speak the language of most of the witnesses. Almost none of us are so immersed in the culture or customs from which those witnesses came to be able to distinguish on some occasions between something that was normal and something that was preposterous. And the exercise that is demanded of Your Honors is far removed from the cornerstone of a fair trial in many countries, where there is a right to be tried by a jury of one's peers. In other words, those from the community in which the crimes are alleged to have taken place, and who presumptively are the ones who are best placed to assess complex issues and subtle issues like credibility, like plausibility. We need only imagine what it would be like if we were alleged to have committed a crime in our own countries, and we were then taken away, removed from our country, removed from our language, our native language, and put on trial before judges who don't speak our language and don't speak the language of most of the witnesses. And to imagine all of the contextual factors that we would see, that we would understand, that we would know because we grew up in the society, because we speak the language, that we know or at least suspect or believe that the judges might have a very difficult, and the lawyers for that matter, might have a very difficult time accessing and understanding. Now, Mr. President, we have faith that your honors can nevertheless do that, not least because of your collective experience in the unique setting of international justice. And yet, not infrequently over the last 3 years, I suspect that you have shared at least my own puzzlement on occasions about exchanges with witnesses, and whether what I was listening to was an outright shocking lie or something that was just based on an innocent misunderstanding, whether it was something entirely implausible or just a reflection of a context that I could not understand or empathize with, as so inconsistent with previous statements that you couldn't help but come to the conclusion that the witness was lying, or whether or not it was something as innocent as an interpretation error. Now, of course, the purpose of this discussion is not to say that the outcome of any international criminal trial should be an acquittal, or that we should just throw up our hands and walk away from international justice. But the purpose of this discussion is to remind ourselves of the many unknowns that exist in international trials that simply do not exist in domestic cases. And those unknowns permeate this case, whether it comes to weighing the plausibility of a witness's narrative, assessing the likelihood that a contradiction was an indication of lying as opposed to innocent mistake, assessing the age of a person based on physical appearance, evaluating the likelihood of contamination or collusion amongst witnesses, weighing the extent that ethnic animus might influence testimony, and weighing the testimony of Mr. Ntaganda himself, such as was brought up this morning with the suggestion that he asked for clarifications too many times, and the inferences that should be drawn from that. And we say that in respect of all of these issues, which all involve unknowns and more, eliminating reasonable doubt must be approached with an awareness of those unknowns. And those unknowns affect one other dimension of your reasoning, which is seldom referred to, but extremely vital to your analysis. And that is, what kind of evidence do you expect to be brought to the court in order to establish proof beyond reasonable doubt? This is something that I suspect. I've never been a judge. I have worked with judges. And I suspect that this is something that judges come to learn based upon long experience of many cases in the courtroom. You know what kind of evidence should be available. You know when the evidence that should be available is not presented. And you do necessarily draw inferences from the non-presentation of that evidence unless there is a good explanation for it. And Mr. President, to be clear, the defense bears no burden whatsoever. If there is any burden whatsoever, it is to show only that there is reasonable doubt in the prosecution case and that the prosecution has not met its burden. This burden is terribly easy to, that's very easy for me to say, but it's also very easy to misapply, as is the prosecution's criticism of the defense at, for example, paragraphs 42, 56, 71 of their response brief, in which they criticize the defense for relying on prosecution witnesses in part who are otherwise suggested as being unreliable or untruthful. But, Mr. President, the defense is entitled to do that, and it's entitled to do that without explanation. This is the case because the testimony of a prosecution witness that is otherwise unreliable or untruthful can still raise doubt about the prosecution case, especially when the prosecution itself continues to rely on the reliability of the entirety of that witness's testimony. The same is not true, however, when the prosecution tries to pick and choose or suggest that one of its own witnesses either lied or was unreliable in part. Given the burden of proof, it's up to the prosecution to provide an explanation to your honors as to why you should be able to rely on some part of a witness that even the prosecution says in part was either a liar or untruthful. Now, I must say that the prosecution has almost never done this at all, because in the end it appears that the prosecution takes the view that each and every one of its witnesses, even witness P10, was truthful in their entirety. Not a single witness presented by the prosecution whom the prosecution says was unreliable in any degree. Other examples of the reversal of the burden of proof in the prosecution's submissions is its suggestion that the anonymity of the sources relied on by P315 during her testimony, her failure to disclose, should be disregarded because, quote, the defense did not seek to compel P315 to provide them, unquote, paragraph 98 of their response. The assertion that the defense had presented, quote, no reliable evidence that the absence of logbook messages meant that Ntaganda's phony was switched off or not plugged in, response paragraph 106. Asserting at paragraph 166 that the defense had, quote, conceded, unquote, that P898 had been enlisted in the FPLC by noting his testimony at paragraph 579 of the defense brief about what he purportedly saw. So even when the defense says that it's only purportedly, this apparently is to be used against us as a concession. Asserting at paragraph 179 of the prosecution's response brief that the defense has conceded that 50 individuals mentioned in one of the documents of P46 were under 15, whereas it's crystal clear from that analysis that the defense's position is that that is merely taking the prosecution evidence at its highest. And yesterday's claim that the purportedly late notice of an alibi, which we reject incidentally, Mr. President, that late notice, quote, is a basis for your honors to infer recent fabrication, unquote, by Mr. Ntaganda, and that was at page 30. All the foregoing suggestions to your honors of reasoning that you should follow are based on either the stated or unstated premise that the defense bears a burden, but it does not. Now, Mr. President, we come to the second issue, which is the proper interpretation and elements of the extended forms of commission under Article 25(3)(a) that have provoked some discussion between the parties in their submissions and yesterday. The UDCC alleges that Mr. Ntaganda committed all the crimes listed therein through a common plan to which he agreed and which he participated with other persons. In fact, that's at paragraph 1 of the UDCC. Now, as you can see, and I'm sure your honors are terribly familiar with this paragraph, this alleged common plan mixes criminal and non-criminal elements. And of course, there's nothing wrong with that. That is permissible. The prosecution can refer to ulterior objectives of a common plan if it wishes. But we nevertheless should be clear, and it's not always clear in some of the submissions we've heard, that assuming military and political control of a region, of territory, even through force, is not an international crime. Expelling civilians is an international crime, and using murder, rape, sexual slavery, and other international crimes for that purpose or for any purpose at all are also international crimes. Now, Article 25(3)(a) says, quote, "A person shall be criminally responsible and liable for punishment for a crime within the jurisdiction of the court if that person commits such a crime, whether as an individual, jointly, or with another, or through another person." 25(3)(a) therefore extends commission liability beyond the situation where the perpetrator acts on his or her own, as when a person swings a machete to execute a person, to situations of acting jointly with another or through another person, such as swinging a machete together with another person or getting another person to swing that machete. Do these extensions of the physical manner of committing a crime that are set out in 25(3)(a) modify or change the mens rea of commission? No. Article 25(3)(a) says nothing about mens rea. Article 25(3)(a) does not set different levels of mens rea for any of these forms of commission, which means that Article 32 and Article 33 apply equally to all three forms of commission set out in Article 25(3)(a). We hope, Mr. President, that much, at least in that far, we are in common agreement with the prosecution. The issue becomes difficult and is difficult to analyze because it is relatively easy to discern criminal intent when a person swings a machete to decapitate someone, as opposed to people who have more remote connections to the act itself. In other words, when the alleged co-perpetrator's contribution is removed from the crime. And by the way, let's remember what mens rea means. Mens rea is not a general disposition. It's not about your character. It's not about whether you're a good or a bad person. It's not about whether or not you have say discriminatory things or have discriminatory ideas. Mens rea is the purpose with which the contribution is performed. Now, Article 30 defines the intent with which the act set out in Article 25(3)(a) as requiring that the person either, quote, in relation to a consequence, that person means to cause that consequence, or is aware that it will occur in the ordinary course of events. The notion of a person who means to cause a prohibited consequence is readily understood. But what does the phrase "is aware that it will occur in the ordinary course of events" mean? There's already rather extensive jurisprudence about this at the ICC, and in fact, extensive prosecution submissions in those cases. Both that jurisprudence and those submissions have used the terminology of second-degree intent. But without getting into a discussion of terminology, what really matters is the content of the concept. And one of the most useful descriptions, we say, of the content of the concept was set out in the Article 70 trial judgment in the Bemba case, which said, quote, "Dolus directus in the second degree requires that the witness does not need to have the will, intent, or desire to bring about the material elements of the offense. Rather, he or she is aware that those elements will be the almost inevitable outcome of his or her acts or omissions." And then the last sentence reads, "In this case, the cognitive element overrides the volitional element, i.e. the witness's awareness that his or her acts or omissions will cause the undesired prescribed consequence." Now, these words, Your Honors, are clear enough and probably require no additional comment, except to say this, because it's irresistible. What you can see from reading this passage is that, first of all, these are considered both types of direct intent. And secondly, that the notion of cognitive awareness that is deemed sufficient is very close to the notion of willfulness itself. Now, the prosecution itself in the past had no difficulty, except perhaps with the Latin, in referring to Article 32b as indeed referring to direct intent, and characterizing that indeed as direct intent of second degree. That's what the prosecution previously has been submitting, is the meaning of Article 32b. In fact, the submissions that you see in front of you, of course, were from the Lubanga case, when the prosecution argued that the trial chamber had not erred. Why? Because the trial chamber had not applied a standard lower than what you see on the screen in front of you. The prosecution also said, and this is particularly salient for some of the submissions that you have now before you, quote, that the standard applied by the Lubanga trial chamber, quote, is consistent with the literal interpretation of this provision. So even the prosecution in Lubanga said there is no problem and no inconsistency between this labeling or this terminology and the content of the provision itself. This same standard of intent applies in the case of all three forms of commission in Article 25(3)(a). Thus, when committing a crime jointly with or through another person, the necessary standard of intent is that the crime is the almost inevitable outcome of his or her acts or omissions. That was the exact language that was used in Lubanga. And this is the standard that applies in the case of an alleged common plan through which co-perpetration is committed. However, this standard must always be assessed, and this is harking back to the language of paragraph 1 of the UDCC, it must always be assessed with reference to the criminal purposes, not the non-criminal purposes. And this is where the language of critical element of criminality in the common plan comes from and why it is so important. Because even though there can be an ulterior motive, even though there can be an innocent objective, even though there can be other reasons why someone is pursuing a particular objective, at the end of the day, what is required for a conviction is that there be this critical element of criminality in the common plan in which the accused shares and agrees to, according to the standard that we've just been discussing, either that you want that outcome or that the cognitive awareness of that outcome as a virtual certainty is present. liability does not arise, and this is very important to remember, but easy to lose sight of, merely because an accused associates with others in a plan whose implementation may result in a crime. It does not arise when the crime is foreseeable or highly likely to the accused. It does not arise merely because those crimes were actually committed. And it does not arise based on a standard even that the accused was negligent or that he voluntarily undertook the risk that such crimes would be committed and nevertheless associated himself and made contributions to that plan. If you do not have the exigent standard of intent that I have just been discussing, then there is no liability under Article 25(3)(a). What is required is awareness that the events will occur, which has been described as meaning a virtual certainty. And this standard is important not just in order to ensure that your honors apply the same law that has been applied in the past to other accused. It's not just that this is the most faithful interpretation of Article 32B. It also serves a vital policy purpose, which is to ensure that your honors are not placed in the position of indirectly criminalizing non-international armed conflicts. To do so would far surpass the jurisdiction of the court. And the fact that a particular rebel movement is viewed by the United Nations as, at a particular point in time, unfavorable, the fact that the rebel movement may be pursued as destabilizing the central government, the fact that there may be neighboring countries that are actively opposed to the group or who say that this group causes instability. None of these things, Mr. President, are properly relevant to your analysis of mens rea. And this comment might be considered unnecessary, except that when you read paragraphs, for example, 826 to 962 of the prosecution brief, it's very hard to see how the prosecution is in fact establishing in any way any facts that are relevant to Mr. Ntaganda's intent. Since each crime with which Mr. Ntaganda is charged in the UDCC through co-perpetration has distinct elements, the standard of virtual certainty must be met separately in respect of each category of crime. Hence, virtual certainty of persecution does not lead to the application of any lower standard of intent for murder. This is the approach that controversially was adopted at the ICTY on the basis of its view that this reflected customary international law. And that view was rejected at the ECCC. In any event, this ICTY jurisprudence is based on much different statutory language than that is in the ICC statute. And therefore, this jurisprudence is not only irrelevant, but in fact also repudiated by the prosecution itself yesterday, helpfully, in saying that it was not seeking the application of a dolus eventualis standard. Mr. President, the prosecution urges you in its brief, in its response, as well as in its oral submissions yesterday, however, that you should adopt an interpretation of Article 30 that is, quote, in keeping with the statute, including the aim to end impunity. But ending impunity also requires adhering to deeply cherished and vital legal principles, including interpreting criminal statutes strictly, for example. The prosecution's assertion that the principle of ending impunity militates in favor of modifying or lessening or liberalizing or changing or extending the clearly defined mode of liability and the jurisprudence that has consistently interpreted it in favor of a more permissive standard should, if that's what they're asking, should be rejected. Incidentally, Mr. President, Article 25(3)(d) sets no lower standard of mens rea for liability. Article 25(3)(d)(1) defines the minimum threshold of liability as, quote, knowledge of the intention of the group to commit the crime. And Article 33 defines knowledge in exactly the same way, with exactly the same words. Awareness that a circumstance exists or a consequence will occur in the ordinary course of events. Know and knowingly shall be construed accordingly. I think I heard the prosecution agree with that proposition yesterday, and if I've misunderstood what was said, I'm sure that they will clarify in the reply. We come now, Mr. President, to the third legal issue, and that concerns Article 74(2) of the ICC statute. Article 74(2) states clearly and unambiguously that a conviction decision shall not exceed the facts and circumstances described in the charges and any amendments to the charges. Your Honors, the UDCC does not specify a single incident of rape or sexual slavery of any child soldier upon which you could properly convict. Not one location, not one date, not one victim, not one perpetrator is identified in the UDCC. What we do have is paragraph 100. The charge accordingly is that Mr. Ntaganda should be available to be liable for these crimes, for any of these crimes committed over a period of 16 months anywhere. This is actually much less limited than the temporal and geographic framework that was found to be insufficient of more specific particularization, found to have been not an appropriate basis for a conviction in the Bemba case under Article 74(2). In that case, the insufficiently defined temporal and geographic framework was that the crimes of murder, rape, and pillage were committed over a period of 4.5 months in the entire territory of the CAR. Now, as the appeals chamber held in Bemba, quote, simply listing the categories of crimes with which a person is to be charged, or stating in broad general terms the temporal and geographic parameters of the charge is not sufficient to comply with the requirements of Regulation 52B of the regulations of the court, and this is the part that's important for your honors, does not allow for a meaningful application of Article 74(2) of the statute. And we say that those words are every bit as applicable, if not more so, to the UDCC in this case, especially in respect of counts 6 and 9. In fact, many of the submissions that you heard and that you've read in the prosecution submissions and that you heard yesterday were either the same or similar to arguments that have already been considered and rejected in the Bemba case. The first argument that you heard was that any deficiencies in the UDCC have been, quote, cured, unquote, through subsequent notice that, and that accordingly there's no prejudice to Mr. Ntaganda. But this argument conflates the pleading requirements of Article 74(2) and the constraints that puts on your honors in terms of the facts and circumstances on which you convict with the notice requirements that arise under Article 67(1) and 67(2). This distinction and the prosecution's failure to understand the distinction was noted by the Bemba Appeals Chamber. And here we see at paragraph 98 that in fact the Appeals Chamber noted that the prosecution made this same argument before it, and that the argument was misplaced because it did not address the issue of how your honors, or how in that case their honors in the Bemba case, were to properly apply Article 74(2). It's nothing to do with notice, your honors. And these are two separate issues and two separate requirements for a very good reason. If all defects in an indictment could simply be cured by subsequent notice, then the function of the pretrial chamber that's set out in the statute in Article 61 would be completely circumvented. A prosecutor could define charges extremely vaguely, leaving substantive notice of the charges at a later time. But this would not fulfill the requirements of the statute, and it would sidestep the obligation and the duty and the authority of the pretrial chamber to exercise judicial control over the content of the charges against the accused. Second argument presented by the prosecution, both yesterday and at paragraph 13 of its reply, is that the Lubanga Appeals Chamber judgment has already, quote, endorsed, unquote, the manner in which the charges have been pleaded in this case. As a preliminary matter, this clearly is not the case in respect of counts 6 and 9, which were not charged in Lubanga. But second, and more importantly, the Lubanga Appeals Chamber was seized of a ground of appeal concerning notice under Article 67.1 and 67.2, not the requirements of Article 74.2 that a conviction must not exceed the facts and circumstances described in the charge. The issue that was decided in the Bemba Appeals Chamber was not raised, was not before, and was not decided in the Lubanga Appeals judgment. The third argument that you heard from the prosecution is that it had no choice but to plead counts 6 and 9 as vaguely as they are pleaded. According to paragraph 13 of its response, this vagueness was, quote, not only permissible but necessary given these crimes' nature. This is simply incorrect, Mr. President. Rapes are commenced and completed at specific times and places by specific individuals against specific victims. These are the facts and circumstances that must be pleaded under Article 74.2. Whether those acts are committed repeatedly instead of just once does not relieve the prosecution of its obligation to set out these facts and circumstances, at least in some fashion. And furthermore, the possibility of rape being committed repeatedly does not set it apart from any other crime known to the ICC statute, whether it be murder, pillage, or any other crime. In fact, rape was precisely one of the crimes in Bemba that was found not to have been pleaded with sufficient particularity, even though there were numerous and repeated rape incidents that were charged and subsequently the basis of the conviction in the Bemba trial chamber. So the prosecution's claim from yesterday at page 36 of the transcript that the Bemba case did not involve crimes committed as part of a pattern is not correct. Incidentally, sexual enslavement is no different, as was proven so adroitly yesterday by Ms. Rabani in her discussion at pages 62 to 63, when she identified the specific discrete instances when the prosecution says that there was sexual slavery in response to Your Honor's questions. In fact, the elements of crime specifies that this crime can be achieved by even a single event of a sexual nature. Mr. President, I am mindful of the time. If you just give me 5 minutes, I can wrap up this point.
5 minutes is no problem.
Thank you, Mr. President. The prosecution's fourth argument is that this case and the way in which counts 6 and 9 in particular, but also other counts have been pleaded, fit into the exception that was articulated in Bemba that, quote, This is not to say that adding specific criminal acts after confirmation would in all circumstances require an amendment to the charges. This is a question that may be left open for the purposes of disposing of the present ground of appeal, unquote. That's Bemba Appeals Judgment, paragraph 115. The first aspect of this dictum, and it is a dictum, not a holding by the appeals chamber, is the use of the term specific criminal acts as opposed to criminal charges. The appeals chamber, I suggest, appears to be contemplating that there may be certain collective crimes defined with sufficient particularity to permit the addition of specific acts within those charges. One example with which your honors may be familiar is the notion of the crime of extermination at a particular location at a particular time or over a period of several days. It might indeed be difficult in respect of such a crime to set out in the UDCC all of the specific victims, all of the specific incidents of killing, and indeed those specific incidents would only be evidence of the larger crime, which is by its nature a collective crime. And we suggest that that is a possible scenario that would fall into the scenario hypothesized, albeit without much explanation, by the appeals chamber in the Bemba case. But we say that that scenario is very different from the entire absence of any temporal or geographic scope that you see in respect of counts 6 and 9, which in any event do not involve crimes that are intrinsically collective. These are crimes that are specific, discrete, individual crimes that simply are not properly charged by saying that they occurred somewhere over a period of 16 months. Mr. President, that does present an opportunity for a break, and I would suggest that we adjourn with your leave until tomorrow.
Yeah, exactly. I'm on the same page. So we completed further part of presentation of defense closing statement. We will continue with the same topic tomorrow morning. According to my information, defense used so far slightly more than 3 hours, 5, 6 minutes, something like that. So there is, I guess, good chance that we could complete the presentation of defense closing during the first morning session, which may take 2 hours. So we will break now and we will reconvene again tomorrow at 9 o'clock.
All rise. Veuillez vous lever.